Minister for Information. Once the Chief Justice is roped into a plan to remove a judge, the process is easy. And that is what happened to the former Judge Amwasechi, that people have not taken very critical knowledge of. Can you imagine any three justices who are biased or appointed for the purpose sitting on the panel? All those limiting provisions of the most senior High Court judge, the most senior Court of Appeal judge are removed. So you can't pick. And then any two persons from the president's own political party. And this can give you a simple majority at any time to remove a judge. It is dangerous, very risky. It is recommended that the following could be a better proposition, though more ideas could come. 2 retired Supreme Court judges nominated by the role of retired Supreme Court judges. You can insulate politics from this. 2 senior lawyers nominated by the Ghana Bar Association at a meeting called for that purpose. 3 other persons nominated from the Christian Council, the Catholic Secretariat, and the Muslim Council. This, for example, would definitely do a better job compared with what we have today in the Constitution. Also, there have been issues regarding capping the Supreme Court members, because the present system gives way for loading the court in the interest of a political party. If we think of this, then like the late Justice Professor Oquaye noted in a very brilliant presentation here at the IEA, you must also look at the constitutional provision which allows by right all appeals from the Court of Appeal to the Supreme Court, so that our Supreme Court today is not only a constitutional court, it's a court of appeal for all kinds of land cases, etc., etc. And the job cannot be done by, let's say, 7 people, as people sometimes want to compare the United States situation with. In the United States, appeals essentially end at the Court of Appeal. If we provide for that, we may also look at limiting the numbers in the Supreme Court. Women. The Constitution must capture the need for affirmative action in public life. Today, people wonder how we can do this without a constitutional amendment. Let us remove all the gaps and the lacunae. The areas include, first, 1/3 of all public office appointments could go to women. Second, the 1/3 membership of the district assemblies should be given to women. Third, women participation in parliament should be enhanced, including the following. A number of ideas are suggested, but one that I fancy very much is, apart from women who will win elections in the normal way, in the national election, after the elections, when we know the ratios, the percentages of votes got by various political parties, the political parties will be given the opportunity to select women of distinction to occupy those seats. So that if, for example, we have 50 seats reserved for women, then a party gets 30% of the votes. It will only nominate 30% of the women, and so on and so forth. At the end of it, you automatically have 50 women to add whatever number we have in parliament and develop as equitably. 7. Political parties and elections. The rise of unbridled financial expenditure, both intra-party and in national elections, is becoming increasingly dangerous. Areas to examine could include limitations on money to be expended on party primaries, since the Constitution requires that the internal management of the affairs of political parties should be in accordance with democratic principles. The law must provide against vote buying On the national level, the screws must be tightened on the financial accountability of political parties. Sanctions must be provided for and applied. Third, state funding of political parties needs a reconsideration. The process must be just, equitable to all political parties, but it cannot be a shield of mere survival for parasitic political parties which spring up on the eve of elections only to collect stage-like guests. The principles to qualify and all relevant controls must be clearly identified together with appropriate offenses and punishments. Corruption. This is a canker which continues to eat developing nations. In Ghana, every coup has been justified for corruption. Incidentally, Rawlings, having seized power and ruled for about a decade with the PNDC and NDC government, lamented in his last State of Nation address to Parliament in 2000, from the parliamentary Hansard we know. He said that corruption was rife after all his revolution, and there was a need to invite World Bank to carry out a diagnostic study on corruption in Ghana. So did we go or did we come? The repeal of the criminal libel law, financial administration measures, and laws etc. were positive steps under President Kufuor, worthy of emulating and expanding. Pontification and mourning never solve serious problems, and useful strategies would include streamline and bring into effect laws clearly regulating corruption as guided by the Constitution itself. Strengthen all institutions which deal with corruption. Salaries, conditions of work, equipment, etc. should be radically reviewed and provided for. Provide a legal regime for prosecution of all cases. The court prosecution continue to collapse, and victims sometimes get away with offenses. SRAG should be reformed and empowered to fulfill its mandate, including prosecution, for example. The budget alone shows it is not taken seriously. The cankerous habit of grantoire, pleading for wrongdoer, must stop. Corruption cannot be eliminated in the cultural milieu where prominent persons, politicians, priests, chiefs, et al. Permanently stand in waiting to plead for an offender as a requisite social obligation. The e-governance program, which will cover the computerization of all aspects of administration, should be brought to a logical conclusion. Customs fraud persists because duties are partly veiled in allegory. When Professor Busia sent passport forms to post offices to be sold there, attendant corruption relating to passport forms ceased. Time frames should be set for all public duties and penalties prescribed for non-compliance. Our contorted bureaucratic procedures create room for corruption. Where public duty cannot be discharged timeously through well-laid procedures, the public servant adopts the tactics of go come tomorrow, till money changes hands. Still fines and penalties should be promulgated to deal with the offenses that we know so well of. Living wage policy should be pursued, and it's rather funny to speak of corruption in the nation where most workers do not live on their wages, and this is well known. Ask all officials in the ministries and elsewhere, so what do you live on? Nobody knows what he lives on. A study done by the Africa Public Policy Institute in 2014, led by this writer, showed that some 90% of respondents boldly stated that no one lives on his or her pay in Ghana. This is an ostrich approach which will never solve any problem. Programs to instill honesty and integrity in the people from cradle to the grave are necessary. Programs to name and shame offenders. The promotion of accounting procedures in the public service is crucial. Ghana needs well-trained accountants in all aspects of public and private activities. Our institutions must be made to produce graduates that will satisfy the nation's needs and aspirations and instill good practices in all aspects of financial administration. National planning. It cannot be gainsaid that the National Development Planning institution is necessary. Nevertheless, the present state of a pendulum development whereby government introduce new policies during their tenure only for such policies and attendant projects to be abandoned immediately these governments leave office is most unfortunate. Article 35(7) actually provides that as far as practicable, the government shall continue and execute projects and programs commenced by the previous government. But the politicization of the NDPC and the abandonment of various projects stated by the previous regime is greatly hurting the nation. We need to visit the challenge again, and I suggest the following. Membership of the NDPC must be neutral, expressly beyond political consideration, and professional. Institutional representation, and I keep on mentioning institutional representation, it is something that we continue to think of very, very clearly. Institutional representation is better than human appointment. Institutional representation from those with expertise in national planning will largely lead to independence and technocracy. This will encompass economists, researchers, planners, environmentalists, academics, etc., who will be 9 members to head the commission. The commissioners shall elect their own chairperson and vice chairperson. The whole office for a period of 6 years, renewable for 1 further term, save that they shall retire at the requisite retirement age. Their tenure shall be separate from that of the president. The commission shall have power of enforcement of NDPC programs. Relevant ministers and other officials who are in breach of the national policy will be summoned to explain themselves and sanctioned. Appropriate reports shall be made to Parliament and other national institutions to ensure compliance. In the period where a government is experiencing economic prosperity, the fashion is to cut short for development as many as possible. Fiscal sense is often ignored as political considerations capture the hemisphere and cause governments to overstretch. Inevitably, this propels the days of economic malaise and projects are later abandoned. We need to assess how projects of various regimes have fared. Issues of unemployment, national housing deficit, education, including free SHS, health issues, including NHIS, agricultural development, including self-sufficiency and planting for food and jobs, cocoa policy, pollution of the environment and population, affirmative action on women, 1D, 1F, fiscal management must be captured and nationalized, and they will not in principle belong to any party. The better management thereof will determine the competence of a particular government from time to time. Such assessment made by high-powered national institutions without fear or favor will promote good governance. The question is, how do we ensure that autonomy prevails on these commissions? Our mandates at the Institute. The mandate of the Center include to undertake a thorough study on proposals to review the 1992 Constitution of Ghana as aforesaid, to broaden the understanding and application of constitutionalism at all levels of governance and daily lives of Ghanaians. Studies in this regard will include theory and application of the 1992 Constitution, the Supreme Court on Wheels, judgments on various decisions by the Supreme Court since 1993, constitutional cases in the Fourth Republic, including the right to demonstrate. Some people don't want constitutionalism today, but they enjoy having the right to go on demonstration. They don't know that constitutionalism brought that right that they are enjoying today. Understanding the 1992 Constitution of Ghana, a simple, well-explained version of the 1992 Constitution in English and other languages. Essays on the Ghana Constitution, invitation for papers. 1992 Constitution of Ghana explained. IEA constitutional papers. Historical study, constitutional development in Ghana, study of colonial times, First Republic, Second Republic, Third Republic, Fourth Republic. It will help us, for example, to know why is it that something was better in the Second Republic, but it was removed in the Fourth Republic. They will do a sankofa and go back for it. It will help us also to appreciate that under the 1960 Constitution, for example, the president will suspend the Constitution and rule by decree from Flagstaff House by law according to the Constitution, Article 55 of the 1960 Constitution of Ghana. And also, there was nothing like complaining when you were arrested and asking that you have been kept for more than 48 hours. When we know this, then we will appreciate what constitutionalism has really done for us and appreciate how to go about calling for backward movements. Documents and papers on constitutional development in Ghana. This will include deliberations and proceedings of the commissions or assemblies which drafted the Constitution. So that if, for example, the Constitutional Commission before the 1992 Constitution advised that former heads of state should be included in the membership of the Council of State, and yet it did not appear in the Constitution itself, then you also ask yourself, why does it not appear? Because that is a better option. These are the ways to appreciate the essence and the benefits of constitutionalism. Constitutionalism in Ghana, the trial of the martyrs, Ray Akoto case, Dankwa in action, etc. The IEA debate discourse on constitutional studies, monthly round tables, know your rights and obligations under the 1992 Constitution. The 1992 Constitution of Ghana, your rights and obligations, capping of the Supreme Court, to cap or not to cap, to promote good governance in public affairs, civil society, political and economic institutions should be part of our national lives. Conclusion. The constitutional process must be inextricably linked with good governance and development in our nation. We should seriously re-examine our governance as a people so that whenever a lacuna is found, we tighten the constitutional screws to achieve desired goals. Let us take the example of MPs being board members of public corporations. Even though no provision specifically provides against this, it is clearly a case of conflict of interest, as those who are to hold public corporations accountable are themselves members of the boards of such institutions. It flouts the principle of probity and accountability under that very constitution. I know that President Kufuor and President Mills did not initially approve of this practice at all, but after elections, some MPs in their parties who could not be made ministers complained vehemently till they were compensated with chairs or members of boards. These are things that have really happened and should lead us for the future. To avoid all doubts, a constitutional mandate should be provided to prohibit this. Then no one can blame the president and no one will seek for such appointment, especially when all members of parliament have no executive jobs anyway. Furthermore, several issues regarding affirmative action have been discussed at length, but to no avail. It is now time to seriously make provisions regarding female political representation and participation in public offices and place these beyond the wishes of any particular government. Finally, there are certain glaring maladies regarding our natural resources which we must provide for constitutionally to compel compliance. Rwandan President Kagame has very recently come out against the practice of African leaders who give tax concessions to mining companies and others. At the same time, our leaders remove or fail to apply subsidies which will benefit our local manufacturers. The entire concept of tax concessions must be re-examined. Concessions given since the commencement of the Fourth Republic should be looked at, and provisions or laws should be made to regulate or limit the hands of future governments. This also applies, for example, our oil concessions in accordance with certain recent announcements made by an eminent Norwegian as to our selling our oil cheap. In conclusion, constitutionalism must beget good governance. Constitutionalism must beget good governance. And good governance must manifest, reflect, and echo the glory of constitutionalism. This is the symbiotic symmetry which should guide African nations to stability, democracy, and development. This is our mandate, and this is our goal. Thank you very much.